Sorry, I was having a difficulty with my system here.
All right, Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We are on the record calling case number 201600536, United Lab versus City of Detroit. Your respective appearance.
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
Good morning, Your Honor. Raymond Garant on behalf of the City of Detroit, P79349.
Counsel, I can't hear you.
Raymond Garant for the City of Detroit, P79349.
Okay. Is our discovery completed in this file?
I still am looking for answers to my discovery from plaintiff. However, Your Honor, I believe that there's a motion to intervene in a Third Circuit court case.
What's the story on
That
this?
is correct, Your Honor.
And when is that scheduled to be heard?
Currently, it is scheduled for tomorrow morning to be heard.
Oh, okay. So if I had you guys come back next week, we'll know the answer on that, whether you're still my problem or not.
We should, yes, unless for some reason that it gets moved, but I have it scheduled for tomorrow.
Who's the judge?
Judge Ewell, Your Honor.
Oh, he'll hear it tomorrow. All right, let's get you guys a date then, a short date, and we'll get you back here and then we'll get you on your way. How about November 19th, which is a week from today? Does that work for everybody?
Yes.
My computer is currently loading, and yes, actually, that works perfect for me next week.
All right, November 19th, 2020 at 10 a.m. We'll continue today's pretrial and results of motion to intervene. So there's really nothing else we've accomplished today, is there?
No, Your Honor, there is not.
Okay. Then what I will do is I will send out to both of you notice of a next pretrial, November 19 at 10 a.m. And we'll learn the decision on that motion to intervene. How old is the circuit court case?
Actually, it's pretty new, Your Honor. I think we filed it within the last couple of months.
Okay, so we might be able to get this one done.
Yeah, I'm expecting that it will be granted, but you never know.
You never know. I understand. We'll talk to you guys in on the 19th. Okay?
Great, thank you.
All right. Thank you all for coming in. We're off the record on your file. Mr. Grant, do you have any other files with me?
Yeah, yes, I do, Your Honor. I'm covering today for Mr. Michael Otten.
Oh, so I should not remove you then. Okay, hold on.
And I'm sorry, Your Honor, that was 10 a.m. on the 19th.
All right, I have a bunch of people here today. Good morning.
Good morning, Judge.
Your Honor.
Let's see who we got. Ms. Greco, what brings you here today?
Excuse me, I'm here for Focus Imaging, case number 15. Yes, and I'm also covering for my coworker Sasha Griffin on case ending in 475.
Okay.
I'm here for that one, Judge.
Who's that?
Kevin Green.
Oh, Green. Okay, I see you. Ms. Abra, what are you here for?
I'm also here for Focus Imaging, Your Honor, for plaintiff.
Okay, so I have both parties on Focus Imaging and Michigan CRNA, right?
Correct, Judge.
Yes, Your Honor.
Okay, then Mr. Brown, you're the odd guy out. You're here on Bass Transport, right?
Yes, I am, Your Honor. I'm for the plaintiff, Baz Eagle.
Okay. And Mr. Grant, are you here covering that one?
Yes, Your Honor.
That's the one you're covering. Okay. So let's do this. I had Mr. Grant first, so let's put the rest of you into the waiting room and we'll get you out and we'll keep Mr. Brown and Mr. Grant, and then we'll get back to you folks on the other one. Okay?
Thank you.
All right, Ms. Abro, you're going. Mr. Green, you're going. And Ms. Greco, you're going. And Ms. Abro, you didn't go.
I did not.
Now you're going. No,
No.
you're not leaving.
I'm not sure why.
Apparently, you're not leaving.
No,
So I guess if you're not going, then I guess I better do your case.
I guess.
Which file do you have again?
I have focus imaging with Miss Greco.
Okay, so I'm gonna put Mr. Durant in the waiting room, bring Ms. Greco out. We'll try getting the case we can hear. All right, Mr. Grant, we'll have to get back to you. For some reason,
Okay.
Ms. Abro won't leave. Okay, now I seem to have a pair. This is the case of 20154-841, Focus Imaging LLC versus City of Detroit. Your respective appearance.
Good morning, Your Honor. Christina Abro here on behalf of Focus Imaging, P78224.
And Fiola Greco appearing on behalf of the City of Detroit, P83874.
Okay, how are we doing on our discovery? Are we about done? We've had discovery now open since August.
We have exchanged mandatory disclosures, Your Honor, both defense and I did send out some discovery. I don't believe I received that back from defense yet, but I have sent out our responses to the discovery, so they should have everything from us.
Ms. Greco? Ms. Greco?
I think she froze, Your Honor.
Hey, this isn't working too well. Ms. Greco? Now, let me take her out and then bring her back and see if that works.
Okay.
Don't go away. Don't. I'll be right back. I'll see if we can get her back here.
We did,
Oh, she's back.
Oh, okay.
I'm sorry. I'm having connectivity issues.
We seem to be having that today. Ms. Abro indicates that you owe her some discovery. Is that where we are?
Yes, and we should be getting that back to her early next week at the latest. But through the course of discovery, we've come to find out that there was another lawsuit filed on behalf of the underlying claimant in Wayne County Circuit Court, which is also representing these bills from Focus Imaging. So I would ask, Your Honor, that we get a 30-day extension. I don't suspect we need 30 days, but just to figure out who is actually representing these bills, whether it's the lawsuit filed in Wayne County or here.
How old is that Wayne County lawsuit?
It was
I'm sorry, I'm losing you.
month after
Let's try it again.
this one. So
When
late
was Wayne County
August.
Let's start
We-
again. When was the Wayne County lawsuit filed? I think I lost her again.
Oh, Wayne County lawsuit was filed about a month. Can you hear me now?
Yes, I got you now. Was Wayne County
Hello?
lawsuit filed about a month
Okay,
ago?
I'm sorry. About a month after this suit, so in late
the-
August, we are exchanging discovery in that case as well.
All right, so let's give you another date. Does December 17th work for both of you?
Yes, Your Honor.
How about you,
One,
Ms. Greco?
yes, that works for me as well, Your Honor.
All right, December 17th. At 10 a.m., we'll try this again. Let's get Ms. Abro's discovery to her. And let's find out if this lawsuit is going to continue or not, or if you're going to intervene into the matter of circuit court. Is there anything else we can do today?
That is all, Your Honor.
Anything for
All
you,
for me
ma'am?
in this case as well. That is it for me on this one, Your Honor, too. Thanks.
All right, so I'm going to remove Ms. Abro, but Ms. Greco, you're staying around for another file. Is that what you're telling me?
Yes, I am covering for my coworker on 475.
All right, let's see what else I got. You don't go anywhere. I'll put you in the waiting room. Ms. Abro, I'm removing you.
Okay, thank you, Your Honor. Have a good day.
You also. All right, Mr. Grant, which file are you here again on?
20-153712.
Okay, Mr. Brown is here on that one. All right, I think I have both parties now on file number 20-153712, Bass Eagle Transport versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Alexander Brown on behalf of Baz Eagle P79951.
Good morning, Your Honor. Raymond Garant on behalf of the City of Detroit.
Mr. Grant, I'm not hearing you.
Raymond Garant on behalf of the city, P79349.
All right, gentlemen, where are we on this file?
Your Honor, we have recently exchanged discovery. I had a chance to go through the claim file from the defendant earlier this week. There are just a couple issues that I had emailed lead counsel on this, so we're kind of working through. I found out that it looks like there were a couple payments that were made by the city. 2 different checks had been issued to my client. The only question is what dates of service those checks cover. So I followed up with lead counsel on the matter. He's looking into getting some more information from me, when the checks were issued, when the checks were cashed, and then explanation of benefits so that I can see what dates of service were paid and what weren't paid. And that'll help us nail down exactly what's outstanding in the claim.
Your Honor, I was led to believe that discovery was complete. Mr. Auten did tell me that there were, like Mr. Brown said, some issues they are working to tie up, but he said that they should be able to get this settled soon.
All right, here's what I'm going to do then. I'm going to close your discovery and give you a return date of December 17th. Does that work for everybody?
That will work for me, Your Honor.
This
Yes,
is
Your Honor.
December 17th at 10 o'clock. We'll try this again. Your discovery is now closed. We can get this little information about who owes, what's been paid and all that. You can get that done without anything else formal. So is there anything else we can accomplish today?
No, Your Honor.
I think we're all set, Judge.
All right, here's what we're going to do. We're going to close your discovery. We'll see you again December 17 at 10 o'clock. Let's get these little who paid what for whom. Let's get that done so we can get this file moving. Okay?
Will do, Your Honor. Thank you.
All right. Now,
Thank you.
are you staying around, Mr. Grant, or are you done?
I am done, Your Honor.
Mr. Brown, I know you're done, so I'll remove both of you gentlemen.
Thank you.
All right. Have a great day, gentlemen.
You as well, Judge. Thank you.
Thank you. Good morning.
Morning again, Judge.
Good morning.
I think we have everybody here now. Let me finish this, my last case here. All right. We are on the record now. Sorry about that. We're on the record now with file number 20151-475. Michigan CRNA Staffing versus Detroit and Detroit Anesthesia Group versus City of Detroit. Your appearances.
Morning, Judge. Kevin Green appearing on behalf of the plaintiff.
Our number.
67515.
Counsel.
And FDO Greco appearing on behalf of the city, P83874.
Okay, you guys' discovery has just closed as of November 7th. Where are we on this file?
wait.
Your Honor, I'm sorry, go ahead.
No, just waiting from the city of Detroit. That's really it.
From what I understand, Your Honor, we're having a similar issue to my previous case with this, where the bills for this provider case are also being represented in a case filed in Wayne County recently for the underlying claimant. So we would just ask for a short extension and discovery to sort out who's going to be representing these bills.
Why do you need more discovery? I'll give you another pretrial date, but all you're going to be doing is going to the file and finding out who the lawyer is and giving them a call, basically, right?
Yes, we did attempt to contact the opposing counsel on the other case and haven't heard back from them yet.
That's
So,
not Mr. Green.
no,
that again?
on the Wayne County case, Your Honor.
Oh, okay.
So yes, we are just waiting
All
to hear back.
Then your discovery will remain closed. I'll give you a December 17th return date.
Thank
Judge,
you.
can we get a trial date?
Counsel, I don't set trial dates before I know what's going on. And you don't know what's going on yet until we find out what's going on in this Wayne County Circuit Court case. You don't even know if you have a case.
With all due respect, Judge, my client did retain me. I do have these bills. And this is just one of many that the city of Detroit has delayed and denied. Bottom line is I have cases back from February where I'm waiting for releases. I mean, enough's enough.
December 17th, people. Let's get
Thank
this
you,
done,
Judge.
Greco.
Have a great day, Judge.
Thank you, Your Honor.
I
Same
need-
time.
Yes, 10 o'clock, but you need, and the city needs to do a better job of being more aggressive on these files. I mean, you're in the building. It's just a matter of going over, pulling the file, getting a name and number, and picking up the telephone.
I understand, Your Honor, and I do apologize. We have experienced a significant delay with a lot of things for the last 6 months, but
Yeah, I noticed.
we will do, as I said, we've gotten in touch with opposing counsel on the Wayne County case, so we're
Here's what's happening.
hoping.
I'm having a number of cases where lawyers like Mr. Green are just frustrated with the city's slow pace of doing things. That slow pace causes friction, which interferes with the resolution of cases. My business is not how well y'all get along. I don't care. My business is a resolution of files. And I cannot resolve files if one side is dragging their feet. So let's get moving on the file. December 17th, 10 o'clock, we'll try this again. Thank you both for coming in. We'll
Thank you,
send out a
Judge.
notice. We're off.
Thank
the
you,
record.
Judge.
What I'm doing. I know what I'm doing. Good morning.
Morning, Your Honor.
Good morning, Your Honor.
Mr. Riddell and Ms. Newman, I have one more matter on my calendar other than you. You guys obviously will take quite a bit of time. So what I'm going to do is I'm going to put you in my waiting room. I'll do the other file that I have, and then we'll get back to you so we won't have to be worried about being constrained for time, okay?
Sounds good, Your Honor. And just to let you know, I believe one of my clients, Joey Delgado, may be in your waiting room as well.
Yeah, I see Mr. Delgado there.
Perfect. Thank you, Your Honor.
But right now I have only one of the two parties for the other side, but if they're not here within the next 5-7 minutes, then they'll just have to wait. But I prefer to get them out of the way so I can give you guys my undivided attention.
Sounds fair.
Okay. I should also tell you, Mr. Riddell, your client is certainly welcome to observe. He will not be permitted to offer testimony.
That's correct. He's aware of that.
Okay. Okay. Let me put you guys in the waiting room.
Thank you, Your Honor.
Thank you.
Good morning.
Good morning. Ms. Dolan, good morning.
Good morning, Your Honor.
We are on the record. This is case number 20150-268, entitled Advanced Surgery Center, Southeast Michigan versus City of Detroit. We have a motion concerning discovery and we have a pretrial. Your respective appearances.
Your Honor, Sylvia Mansour on behalf of Advanced Surgery Center, P number 79241.
And good morning, Your Honor. Sarah Doman, P79128, on behalf of the City of Detroit.
All right, let's get started with the easy thing. Where are we in regard to the motion to compel?
Your Honor, the motion is a moot point at this point. We can withdraw it. We've been trying to do so, I believe, in the past several days, but it just our office hasn't been able to get through. So it's a non-issue now.
All right, so what you're going to do is you're going to send me something on your letterhead by fax indicating your motion the motion is withdrawn, okay?
Okay.
Now, where are we on our discovery? Are we done now?
Plaintiff has received the requisite discovery from defense, and we're just in the process of looking through it.
Ms. Dolman?
I can't remember if did I serve discovery on you, plaintiff, Ms. Mansour?
I don't see any discovery that's been served from
Okay.
the City of Detroit.
In any case, I've gotten the records that I needed. I think Ali sent me them. So I think we have what we need.
So then what I'll do is I'll close your discovery. Then are we in position to talk about resolution on the file?
We did actually start talking about that yesterday, Your Honor. We're in the process. We've already had a little bit of a back and forth, and I think that we'll keep working on that.
All right, then I'll give you a return date. The discovery is now closed. I'll be looking for a letter from counsel for plaintiff withdrawing the motion to compel. Does December 17th at 11 o'clock work for both of you?
Yes, Your Honor.
Yes, Your Honor.
All right, good. So that problem is resolved. Now, I would very much think we ought to be able to kill this case next time we're together, or before then, actually. The PIP cases are pretty straightforward. There's really not much argument about what the claim is. Rarely any argument about what actually did or did not occur. And so let's see if we can't get this file resolved before we are next together. But for now,
Sorry.
it's all right. I had, I guess, a 2-year-old Zoom bomb the docket last, I guess it was Tuesday or Wednesday. Just decided you want to talk to Daddy. So here I am.
Oh,
December 17th at 11 o'clock.
okay.
And
Thank you, Your Honor.
okay, I look forward to your letter withdrawing your motion.
Okay.
Yes, Your Honor.
And are we that's just being considered a settlement conference?
Just, it's no. The settlement conferences, I make people come.
Okay.
We're gonna
So-
do this as a pretrial. If
Okay.
we can't get it settled, then what I'll do is I'll set it for a settlement conference, and we'll require that trial attorneys and people with settlement authority be present on Zoom.
Okay.
I've never done a Zoom settlement conference. I really don't know how I can bang heads on Zoom. So I'm not sure if it's about the sense, but at least we'll try that if it comes to that.
Right.
So
Well, we'll try not to get to that point.
December 17th at 11 o'clock.
All right. Thank you, Your Honor.
Thank you.
Thank you both for coming in. We're off the record for your file.
All right.
Have
Bye.
a great day and be safe.
You
You
too.
too.
We are on the record calling file number 19177-428, Banyan Property Management versus Anjanette Joseph Delgado. We have motions for summary disposition filed on behalf of both sides. Your respective appearances.
Good morning, Your Honor. Chantal Newman appearing on behalf of the plaintiff counter defendant Banyan Property Management Services LLC, P70569.
Good morning, Your Honor. Sean Riddell appearing on behalf of defendants counter plaintiffs Anjanette and Joseph Delgado, P81302.
The record should reflect that Joseph Delgado has appeared. The court has muted him since he is not able to offer testimony at this hearing. Your argument, Ms. Newman, Mr. Riddell, and I think we'll just proceed in that fashion. Ms. Newman, you can make your motion, your argument for summary disposition. Mr. Riddell, you can respond to her, and then we'll let her respond to your response. Then we'll hear each from you in your response in regard to your motions. We'll hear her response, and then you can respond to that. Okay?
Okay, thank you, Your Honor. As a preliminary matter, just in consideration of the court's time, I was wondering if Your Honor could give guidance as to whether you're entertaining any further arguments on the validity of the lease in light of the previous hearing.
The validity of the lease, the enforceability of the lease, the terms of the lease, in my judgment, that ship has sailed. My review of the docket here indicates that this is the lease between the identical parties that are before me today. Further, it appears that at the time of the trial in this matter, looking at the register of action appended to the plaintiff's motion for summary disposition, judgment was entered on February 14th, 2019, and the court record indicates that both parties appeared at that hearing. In my judgment, the validity, the enforceability, and the terms of the lease are res judicata.
Okay, Your Honor, I will just get right into our breach of contract count then. So Banyan filed this suit as a result of the Delgado's breach of a residential lease. That lease was entered into on June 28, 2018, and the Delgados vacated at the end of September. So they were there for only 3 months of a 12-month lease. And Banyan suffered great damages as a result. So they have filed this suit for breach of contract. As Your Honor knows, there's 3 elements of that: the terms of the contract, the breach of those terms by the defendants, and injury to the plaintiff resulting from the breach. I don't believe there's any dispute as to the terms of the contract. The dispute comes into as to whether the Delgados breached the lease. Obviously, the Banyan is arguing that they breached the payment terms first. The Delgados are arguing that Banyan breached the repair terms first, which I'll get into that when I discuss their affirmative defenses. But as far as the damages, Banyan suffered lost rent, late fees, marketing costs, legal fees totaling $13,491.92 as a result of this lease or breach of the lease by the Delgados. So to address their affirmative defenses, the defendants have alleged 4: breach of implied covenant of good faith and fair dealing, constructive eviction, unclean hands, and failure to mitigate. As far as the breach of implied covenant of good faith and fair dealing, Michigan does not recognize such a claim, and that's laid out in Belle Isle Grill Corp. versus City of Detroit, 256 Mich. App 463. So that defense fails pursuant to MCR 2.116C9. Moving on to the second affirmative defense of constructive eviction, pursuant to MCL 629-18, there has to be some kind of interruption of service that is essential. It lays out heat, running water, hot water, electric, or gas service. It does not specifically state air conditioning as an essential service. And the Delgados did not
assert that it was an essential service, and they did not cite any Michigan case law stating that. So on its face, that defense, sorry,
Let me just interrupt you. As I understand it, there was a limited window of time when there was no air conditioning. And the Delgados did not vacate the premises during that time, but after the air conditioning had been restored. Is that accurate?
That's correct. They did not leave the premises. They have not alleged that they could not stay in the premises. They moved out after the air conditioning was fixed.
Please continue.
So as far as the constructive eviction claim, that also fails under MCR 2.116C9. I do want to address the 3 weeks that it did take to replace the central air. That was due to Banyan's due diligence. The reason it was not working is because the unit was stolen. So Banyan sought another alternative to avoid a future theft, which was to raise the units in the air to have a structure so that it could not be stolen. I think if it was the other way around, then the Delgados would be arguing that Banyan didn't do their due diligence if it got stolen. You know, if they immediately replaced and it got stolen a couple days later, then there would be that argument there. So they were trying to find a more permanent solution. So yes, it did take a little longer to replace than normal, but by no means was it unreasonable.
During that 3-week period,
I'm sorry, Your Honor.
am I correct in my understanding that the air conditioning, from your perspective, the central unit was stolen on or about July 26th of 2018, and on or about July 27th, Banyan installed window air conditioners in the kitchen and living room, but not in the bedroom?
That's correct, Your Honor.
All right, go ahead.
The Delgados do attempt to create an issue of fact as to when the repair for the central air conditioning was created or was completed. They attached Anjanette Delgado's, I think it's August 21st and 23rd emails to an Erica White at Banyan. But the only reference to the AC not, you know, the only reference at all to AC is in an email list saying that there were repairs that were not addressed. It doesn't indicate what the alleged issue was with the air conditioning at that point. And Banyan produced a sworn affidavit by its general manager that said the unit replacement was completed on August 15th and 16th of 2018. And that's corroborated by Erica White's email to Miss Delgado on August 14th that said the AC would be completed by the end of that week. Her email didn't state anything about the air conditioning not working at that point. And just to briefly address Mr. Delgado's allergies, the Delgados have not attached any verified medical records to their pleading or to their motion. There's no allegation that Mr. Delgado had to go to the doctor during this time. It's simply they attach an interrogatory that said if he follows advanced allergy and asthma care's recommendations, he'll barely feel the effects of his allergies. But we also received documents that did include a list of the allergies that Mr. Delgado had, which did include dog. And the Delgados admittedly were living with a dog in the apartment. So I think it just shows that there were steps that could have been made to alleviate the effects of the central air conditioning being down for the short period of time that it was. There's no genuine issue that it was repaired. And so I think under MCR 2.11C10, even if the court did find that air conditioning was an essential service, there was still no genuine dispute that it was repaired within a reasonable time. The third affirmative defense is that of unclean hands, and as a threshold matter, that can only apply to the plaintiff's unjust enrichment count, and that's stated in Varela versus Spansky 329 Mish Act 58, 2019, and it says the unclean hands doctrine is only relevant to equitable actions or defenses.
And let's stop right here. Do I even have subject matter jurisdiction in an equitable action? My understanding of the jurisdiction of the district court is that I have, or should I say the district court has equitable jurisdiction only in summary proceedings to retain to gain property. and that equitable jurisdiction is to quote, to determine interest in land, end of quote. So I don't understand how the district court, outside of the summary proceeding, even has subject matter jurisdiction over a claim of unclean hands. Please continue.
As far as raising it as a defense, even if it wasn't an equitable situation that the court could hear, it's when the defendant has unclean hands, they may not defend on the ground that the plaintiff has unclean hands as well. So our argument is the claim, unclean hands defense claim fails on those grounds as well. And that's an AG versus Power Pick Players Club of Michigan, 287 Mich. App 13 in 2010. So Banyan, or the Delgados try to argue that Banyan had unclean hands because they filed the eviction proceedings, but they have not asserted any legal support to claim that Banyan was not allowed to seek a legal remedy that it was allowed to seek at that time. So for those reasons, Banyan argues that the defense of unclean hands fails under MCR 2.116C9 as well. And then the last affirmative defense is that of mitigation of damages. Banyan, in the affidavit of its general manager, lays out the numerous attempts that they made to market. The property was still being marketed since the Delgados were in it for such a short period of time. It was still listed. And so there was never an interruption in the listing of the apartment. They had numerous showings of it, and they reduced the rental rate multiple times. There was a short period that they brought it back up to the amount that the Delgados rented it at, but ultimately they re-rented the property at $500 less a month, and they have not sought damages for that $500 for the remaining 9 months of the lease that the Delgados were not in the rental unit. And so for those reasons, I think there's no genuine dispute. There's significant evidence of the mitigation of damages that Banyan attempted, and all of these four affirmative defenses don't eliminate the Delgados' liability for the breach of the lease and the damages that caused as a result. So Banyan is requesting a money judgment in the amount of $13,491.92, plus the statutory interest from the date of complaint filing, and then costs of $229.48, and then attorney's fees to be proved up as well.
Mr. Riddell.
Thank you, Your Honor. First of all, to go back to our preliminary issue, you brought up the eviction judgment in February of 2019. When we were here for defendant's motion for leave to amend, both plaintiff's counsel and defense counsel informed you that the possession judgment was actually a default judgment, not a judgment by trial. I want to make sure that that's clear.
Yeah, I understand that.
Okay. And
that doesn't change the court's res judicata analysis.
Well, let me address that, Your Honor. So first of all, so summary proceedings for possession of property when there's no money judgment requested does not create res judicata issues for issues outside of issues of possession that weren't actually tried. There's a case.
But let me stop you right there. How do you get, in the case of a lease, how do you get to the question of the right to possession without determining that the lease was valid and enforceable?
Because, Your Honor, the lease is not really the issue, it's title. And as long as there's a superior possessory interest, the plaintiff in an eviction action has the right for the eviction.
But the possessory interest in this case is not a function of title, it's a function of the lease. That was how the possessory interest was demonstrated, was it not?
Banyan owns this
I'm
property.
not arguing that. The point I'm making is that the question of the validity of the lease, in my judgment, is res judicata. Because we are not litigating title. We're litigating right to possession. Banyan asserted that his right to possession was because of the lease that the parties had entered into. The district court must necessarily have determined that lease to be valid and enforceable. So listen.
Not necessarily.
Okay,
Not necessarily, Your Honor.
then we're going to disagree on that. But let me make my ruling clear. Your clients appeared at the hearing. Apparently earlier the court had been informed that the hearing went down by default, but that's not factually accurate. There was a contested hearing. The judge determined that on the basis of the lease that was presented, which was appended to the complaint, was it not?
I don't know that answer, Your Honor.
The lease is attached
No,
to
not
the,
to the complaint here, to the complaint in the landlord-tenant division.
I would have to pull up the plea. I can't confirm that.
I don't know, Your Honor.
Judge determined that possession was to be awarded to the plaintiff. Because we have identity of parties, because we have identity of the issue on the necessary decision that the lease both existed and that it was valid and enforceable, the court finds that to be res judicata. So I've made my ruling in that regard, Mr. Riddell. I understand you disagree with it. You have an absolute right to do so. But I am not going to change my ruling. Please continue with your argument, leaving aside the res judicata on the validity and enforceability of the lease.
Thank you, Your Honor. To address the, so I guess let me start from the top. As Ms. Newman described, this is a case in which two tenants searched for a unit which included central air conditioning. They moved in on June 28th. The air conditioning unit was stolen on July 26th. It is true that in Exhibit 3 of defendant's motion for summary disposition, a chain of emails is attached. In those emails, Ms. Delgado and Ms. White have a back and forth conversation. For much of this time, Ms. White has not updated the Delgado, specifically Anjanette, about what is going on with the air conditioning unit.
Let me stop you right there. In the lease that was appended to the complaint in this matter, I did not see any mention of air conditioning. Did I miss it?
That's correct, Your Honor. This is a very one-sided lease, which is why MCL 554139 is specifically appropriate here. 554139 is the statutory housing covenants, which are implied in all rental agreements. In addition, there are the implied covenant of quiet enjoyment, and to some extent, the implied covenant of good faith and fair dealing, which I'll address in a moment. So even though,
because let me cut to the chase here. I am not in a position where I believe it is appropriate for me as a district court judge to expand the list of essential items beyond the heat to include air conditioning. The legislature had an opportunity to, they clearly were thinking about the heating of the property. They decided that that was going to be an essential service, but they did not decide that air conditioning was. And in this lease, which is silent to air conditioning, I will not make that an essential service, thereby expanding the scope of the statute.
Your Honor, so you're addressing MCL 600.2918. Excuse me, I'm sorry. So, Your Honor, you're addressing MCL 600.2918. There are other statutes that apply, as well as the common law covenant of good faith and fair dealing. And those are the housing law of Michigan 554139 and the implied covenant of quiet enjoyment. And those are not limited to essential services as laid out in 600.2918. The housing law of Michigan does require that these properties stay up to code, which includes having an air conditioning unit. 554139 requires a fitness for use and purpose. Quiet enjoyment requires the beneficial enjoyment of the property. My clients lost all of that when the air conditioning was stolen. Now, certainly an air conditioning unit can be stolen, can be replaced in a few days, nobody would be here. The issue is that the landlord here failed to update the tenants, failed to respond, essentially dragged their feet so that they could get the benefit of an air conditioning unit put in an iron cage on the second floor.
Let me
Mike?
ask this, Mr. Riddell. Let me assume for purposes of our discussion that the lack of air conditioning was in some way a breach of, say, for purposes of our example, the covenant of quiet enjoyment. Would not that breach be caused by an act of criminal conduct, not an act of the landlord, but an act of the criminal actor, for which the landlord cannot be responsible and which as a matter of law is unforeseeable?
Your Honor, I agree that it's a criminal act. I disagree that it is the responsibility of the landlord to make reasonable and seasonable repairs, as well as they really should be updating the defendants that is involved in the covenant of good faith and fair dealing. And it is reasonably foreseeable that an air conditioning unit is going to be stolen. I didn't realize it.
Mr. Riddell, crime by definition is unforeseeable. Isn't that the law in Michigan?
I will be honest, Your Honor, I don't know that answer.
I'm cheating, I do.
Yes, of course.
Because my problem that I have here is that in regard to your purported violations here, the violations seem to me all to be the result of the criminal conduct of whoever the actor is who stole the air conditioning unit.
That may be
I'm not aware of any statute or case law that makes the landlord vicariously liable for the acts of this criminal actor. I'm having a problem with this.
Sure, and Your Honor, I think we're going down two different paths. The issue is not that the landlord let the air conditioning unit be stolen or anything like that. The issue is that the landlord took 4 weeks to repair an air conditioning unit, and the delay was not caused by any outside factor other than their own choice to have the air conditioning unit bolted to the side of a building with a wrought iron cage. That benefit, when combined with the landlord's failure to keep the clients updated, the clients had to make a decision based on the information they had. And 4 weeks after this date, they had no update as to what was going to happen. The plaintiff relies on evidence that is an affidavit that was created during litigation. The defendants are relying on an email chain that is contemporaneous. And if you see in Exhibit 3 to the defendant's motion for summary disposition, Anjanette Delgado says, we're still waiting to hear about the matter of the deposit, and we have the upcoming rent due for September. Also, we have those repair issues outstanding: tub, AC, kitchen drawer, bathroom windows. Email me as soon as you know something. And there's no update, including on the email that Anjanette sends on August 23rd. This is both a breach of the implied covenant of good faith and fair dealing. Plaintiff's counsel is correct. There is no affirmative action for implied covenant of good faith and fair dealing, but it is long at common law an aspect of contracts. There are cases, for example, Burkhart v. City National Bank, which is 57 Mishap 649 at 652, says, and I'm paraphrasing, when performance of a term of a contract is discretionary to a party, the law implies a duty to act honestly and in good faith. This is a one-sided lease, and therefore—
Let me stop you right here. Did you agree with my earlier evaluation that there is no mention of air conditioning in the contract?
I agree.
All right, please continue.
Thank you, Your Honor. And to address that, those terms are implied very directly by MCL 554.139, the statutory housing covenants, and maybe more indirectly through the covenant of quiet enjoyment, as well as the housing law of Michigan, and another statute that I will plan on addressing later. But the Michigan Consumer Protection Act requires that they provide the promised benefits. And one of the benefits that was provided in this in the advertisement of this property was central air conditioning. In addition,
Excuse me, does not the fact that there's a written lease mean that the agreement between the parties is found within the bounds of the written lease?
not necessarily, Your Honor. In residential landlord tenant and certain other areas of consumer protection, there are other terms that are implied statutorily and by common law.
Please continue, sir.
Thank you, Your Honor. Now, as to the issue of a constructive eviction, it is true that my clients unfortunately gave notice to the landlord so as to make the move out as least, as less of a dispute as possible. However, there are cases that say that would describe something like this as a constructive eviction. And
Excuse me, because who in a constructive eviction scenario, who does the construction eviction? Is not the constructive eviction conduct of the landlord, such as to deprive the person who's a lessor with the ability to use the property for the bargain that they had made?
That's correct, Your Honor.
But here, the conduct is the conduct of a thief.
Not solely, Your Honor. There is a case. It is Ponegos v. Fox, 310 Mich 157 from 1944. It's a constructive eviction case in which the tenants waited 14 months before moving out for a failure to repair. And the Michigan Supreme Court still held that it was a constructive eviction based on the landlord's failure to repair, not the actual damage to the property in and of itself.
In that case, was the damage to the property caused by an outside party, a thief? Was it caused by a criminal act?
It was caused by essentially the negligent construction of the property.
So the answer to my question, it was not caused by a criminal act. That's the factual distinction here that I'm having a great deal of trouble with, Mr. Riddell.
Sure, but I guess then, Your Honor, the question would have to be, albeit rhetorically, is at what point has the landlord waited too long, has put their own interests above the interests of their customers for it to be a breach of a breach of good faith and fair dealing or a constructive eviction?
In relationship to that, the lease, which was appended as Exhibit 1, provided it was paragraph 25, if the premises become wholly or partially untenable, landlord shall repair the premises with reasonable speed. In this case, as I understand the facts, a window or more than one window air conditioning unit was in place in less than 48 hours after the theft of the central unit. Is that factually accurate?
I believe so, yes, Your Honor.
And the central air was replaced less than 30 days from the date of the theft. Is that also factually accurate?
That is, Your Honor.
Okay, please continue, sir.
Now, there is a dispute regarding, this is one of the key facts in the case, is their argument, the plaintiffs put the date of the repair at August 15th or 16th, whereas the defendant's evidence suggests at least August 23rd.
All right, let's assume it's August 23rd. The fact of the matter is, your clients did not vacate during the period of time with no air conditioning and stayed for a period of time after the new central air conditioning was installed. Is that factually accurate?
That is correct, Your Honor.
Please continue.
Now, the issue there is what's happening is we're holding the Delgados responsible for taking an above board approach when if they had, in, I guess, anticipation of future litigation, if they had just moved out the next day, we wouldn't be having this discussion. And that's, I think, an unfortunate circumstance here. And again, this case, Ponegos v. Fox, says 14 months. The plaintiff requested repairs never came. Tenants moved out within 14 months and it was still considered a constructive.
14 months, the same as 30 days?
14 months is, so 30 days is much quicker than 14 months.
At what point in time do you move from an inconvenience to a constructive eviction?
When you lose the useful enjoyment of the properties.
How long?
I think that's the question for trial here. This is what our 6 jurors need to decide.
Okay, please continue.
Yes, and to be clear, is for the purposes of today's motion, the Michigan Supreme Court said that it was still a constructive eviction, even though the tenants waited 14 months. Our clients
I
waited.
understand that.
Okay.
I understand your argument, but as I understand the case, you are not talking about a case where the problem, the purported deprivation of quiet enjoyment, was caused by the criminal act of a person other than the landlord. And to me, that's a big factual distinction, Mr. Riddell. I'm having a great deal of trouble overcoming. Please.
I recognize that. And if you would like, I'd be happy to provide a supplemental brief on this case.
No, I'm prepared to decide the case today. So I will let you say whatever you want to say, but I want to be very clear on this. I have not been favored by either party with case law saying that the landlord is responsible for the criminal act of a person not connected to the landlord. Now, had let's say, for example, the maintenance man decided, hey, I'm going to have my buddies come by and we're going to steal the air conditioner. I would have a much different view of the argument that you're making here. But this is a criminal act, which is unforeseeable.
But the landlords,
we can't make landlords guarantors that no criminal activity will occur.
That's correct, Your Honor, and I'm not asking that. I will say that there are cases that do deal with the landlord-tenant context with criminal acts, but they are factually distinguishable from this. The key here is not the criminal acts of the stealers. It's the failure to repair, the delay, the failure to notify the tenants. The tenants had to make a decision based on what they knew, and the landlords failed to make any type of seasonable repairs. Their repairs were done in a manner that was self-interested, and the least they could have done is updated our tenants. When we think about on August 11th, when the tenants gave their notice, what did they know at the time? They just understood the landlord to be dragging their feet. I would like to move on. I recognize
Please
that.
continue.
All right, thank you, Your Honor. Two, I will come back to the issue of unclean hands in a moment. On the issue of mitigation, I think this is the other key factual dispute. And again, for purposes of motion for summary disposition, taken in the light most favorable to the non-movements here. It is important to note that the landlord increased, so they, as plaintiff's counsel said, they decreased the price on the property when they listed the property, they decreased the price, they increased the price, and then over time, they decreased it again. That key issue of what is the intent behind, what are they attempting to mitigate by increasing the price back to where it was?
When they increased the price, did they increase it above the price that the Delgados had been paying?
They did not, Your Honor.
So let me make sure I understand your argument. Your argument is that the landlord, by seeking to relet the place at the rate of or a lesser rate than the Delgados, failed to mitigate damages. Is that your argument?
Half of my argument is that yes, they increased the price during this time, showing no real attempt to mitigate damages. In addition,
please continue, because I'm having, and here's my problem. As I understand, regardless of the day that your client moved out, by the time your client moved out, the central area had been restored.
That's correct, Your Honor.
So when the landlord attempted to release the property at the same rate as the Delgados had been paying initially, they were attempting to release, in essence, the same property. That is, the same amenities, and including the central air.
That's correct, Your Honor.
Please continue, sir.
Now, I would also like to add here that the new tenants moved in, and I don't have the exact date, but I believe it was in April. The date is in the complaint, which means we're talking about essentially 7.5 months. 7.5 months is truly an unreasonable amount of time for a landlord to find a new tenant. Your Honor, if I'm not sure if you noted the address, it's 748 Van Dyke in Detroit. Detroit Rentals, this is a property in either West Village or East Village. I'm not exactly sure the geography. The landlord, I believe, had 50 people express an interest in this, but none of them rented this. This delay over this period of time shows that they did not reasonably mitigate damages. And when taken together, the fact that the landlord moved the price back up and then took this amount of time to close a new tenant shows that they failed to mitigate damages in this situation.
Okay. Is there anything else you want to tell me?
I'm sorry, what was that?
Is there anything else you wanted to say?
I do, yes, Your Honor.
At this point, to Ms. Newman's motion.
Thank you, Your Honor. I'd like to address the equitable issue here. So plaintiff brought a claim of unjust enrichment. It is true that this court, outside of the Summary Proceedings Act, does not have equitable jurisdiction to hear.
Yeah, I can't hear.
That's right, and for that reason, it should be dismissed. Your Honor,
I can't hear the unclean hands either.
That's right. Well, they go hand.
I can't hear any equitable stuff.
That's right. They go together, and therefore they would cancel each other out.
Please continue.
Thank you, Your Honor. I don't believe that Ms. Newman addressed the counterclaims, and if she chooses to, I'd like to reserve my right to respond to that.
No,
And
she was only doing her motion, and we're going to let you continue to your response to her motion. Then she gets rebuttal. Then you get to make your motion. She gets to respond to that.
That's right, Your Honor. I apologize.
That's the procedure I laid out earlier.
I thought she had filed a C9, but I apologize.
Go ahead, sir. Anything else you want to say in response to her motion for summary disposition?
No, thank you, Your Honor.
Ms. Newman, is there anything you wanted to say in rebuttal to what Mr. Riddell has said in relationship to your motion for summary disposition?
I don't think so at this time, Your Honor. I'll wait for the response to his motion.
Now it's time for Mr. Riddell, your motion, sir, for summary disposition.
Thank you. So in this situation, plaintiff alleged breach of contract. However, this claim should be dismissed for the reasons I laid out in the brief, which include, for example, the fact that the plaintiffs were the first breaching party, and that breach was a substantial breach, somewhat addressed earlier under the implied terms of the contract, statutory and common law. We addressed the unjust enrichment issue already on that. And I believe we've really addressed many of the arguments at issue in defendant's motion.
Okay. And Ms. Newman, did you wish to say anything else in relationship to Mr. Riddell's motion for summary disposition?
Your Honor, they have not, I believe it was Urquhart was the case that Mr. Riddell mentioned as allowing terms of a contract to be amended or to be, I believe, to be asserted beyond, sorry, my camera. I'm not sure what he was trying to get at there with the common law elements, but we have an explicit contract that lays out all of the terms between the parties. And he is not given any authority for how you can imply other terms or why you would imply other terms beyond what's already addressed within the written lease. Now, there may be law out there that applies or addresses when there's an incomplete contract or something along those lines that's contrary to common law authority, but I don't think that's a situation here. We have an explicit lease laying out the terms. It does not address air conditioning, as Your Honor pointed out. And this, as Your Honor pointed out, this was an unforeseeable act by criminal conduct. Banyan did not create this issue. They were not negligent in any way. They became aware of the issue and they found a solution for it, and they made reasonable repairs to do that within a reasonable amount of time. And they advised on August 14th that the repairs were almost completed. So I don't really have anything to add other than what I already said in support of Banyan's motion.
Anything else you want to say, Mr. Riddell?
Yes, Your Honors. So back to this issue of good faith and fair dealing. This is an implied covenant. It's recognized in Michigan. It's also recognized under the restatement of contracts as well as Corbin on contracts. There's state case law and there's federal case law on this. Even though the Michigan courts have not recognized an affirmative claim for the implied covenant of good faith and fair dealing, there is the affirmative defense of it. That affirmative defense is there so that so it implies the terms of good faith and fair dealing whenever there is either a missing term or more particularly when there is discretion for a party. I'm sorry, I couldn't hear you, Your Honor.
What is missing here?
Your Honor, you mentioned earlier that there's no terms regarding the repair of the air conditioning unit.
No, the air conditioning unit is not mentioned at all.
That's correct, which leaves
that, and your position is that's missing? A missing term?
I think we all agree that the terms about what to do with the air conditioning unit are missing, making it discretionary. And when a duty under a contract is discretionary, the duty of good faith and fair dealing arises. That duty of good faith and fair dealing would require that the landlord here perform the contract in a manner to restore the tenants to full possession, full use, full enjoyment, and at a basic minimum to keep the tenants informed.
All right. Is there anything else you want to tell me?
I don't believe so at this point, Your Honor. Thank you.
I'm prepared to rule. I want to thank both of you for your extensive briefing in this matter. Certainly a case that's interesting. The matter before the court is a motion for summary disposition filed on behalf of plaintiff as well as by defendant. Because in both of these motions, the court will be considering matters outside strictly pleadings. And they both are plaintiff's motion and defendant's motion, are in essence C10 motions. Claim there's no general issue of material fact. The court is understanding that when viewing a motion under C10, the court is required to give the benefit of the doubt, if you will, to the non-moving party and to be liberal in finding the existence of genuine issue of material fact. As I understand the facts here, the parties entered into a residential lease on June 28, 2018 for the property at 748 Van Dyke Apartment 2. This was a one-year term from June 28th to June 30th of 2019. The total rent that was to be due was $2,250 per month after the first month of June, which was prorated at the amount of $225. Rent was due in advance at the first of the month. It is uncontroverted that on or about the end of September, certainly by October 1st, the defendants had left the property. Now, the issue here relates to how to manage the criminal act of a person or persons apparently unconnected to the landlord. It is uncontroverted, and the court finds, as a matter of fact, that on July 26, 2018, the central air conditioning unit was stolen. Obviously, once it has been stolen, it cannot work. Now, the lease that the parties entered into was silent on the question of air conditioning, although both parties agreed that the unit did in fact have central air conditioning. That central air conditioning was, as again, provided by a unit stolen on July 26, 2018. It is also uncontroverted that on or about July 27th, within 24 or 48 hours of the date of this theft, mitigation efforts were done by the landlord who installed window air conditioning units in the kitchen and living room, but not in the bedroom. And then ultimately, August 24th to 26th, the air conditioning unit was replaced. The delay in replacing the air conditioning was a combination of both the delay in obtaining the physical unit and obtaining from Detroit Furnace a cage, if you would, in which to put the unit so as to prevent further thefts. There was a lease that was appended to the complaint in this matter. That lease, as I've mentioned during the discussions, was silent on the question of air conditioning. Didn't mention air conditioning at all. Didn't mention central air conditioning. Didn't mention window units by air conditioning. Now, there's some provisions of the lease that I think are relevant for my decision. Paragraph 6 provides that the tenant shall reimburse all damages caused by the default, including costs of re-renting the premises, and all rent for the remainder of the term the landlord does not collect through mitigation. Paragraph 23, the tenant shall give 30 days written notice of intent to vacate prior to the termination of this lease. Early surrender of the premises, including surrender accepted in writing, shall not extinguish any of the tenant's obligations under the lease, quote, including payment of all rent received. And then paragraph 25 talks about what happens in the situation where the premises become untenable. The paragraph provides that if the premises become wholly or partially untenable, landlord shall repair the premises with reasonable speed. It does not require instant repair. And I find, as a matter of fact, there's no genuine issue of material fact that when the landlord replaces the central air conditioning with window units the next day, that's done with reasonable speed. Reasonable minds cannot differ in that regard. The new air conditioning was restored. Air conditioning with cage was installed August 15th and 16th of 2018. The affidavit of Mr. Ord makes it very clear, and I note that this affidavit is unrebutted, that mitigation efforts occurred here almost immediately. The parties, the landlord put in window units, got Detroit Furnace out so as to set up a cage so that the problem of theft could be prevented. And I find, based upon the affidavit of Mr. Ord, which I note is unrebutted, that the landlord's efforts to mitigate were reasonable. Reasonable minds cannot differ. There was no requirement of this situation, which was caused, everyone agrees, by a criminal act of a person or persons not connected to the landlord, to immediately, instantly replace the central air conditioning unit. And the fact that the central air conditioning unit had been stolen makes making sure and mitigating damages by making sure it's not stolen again very reasonable. Based upon the affidavits of Mr. Ord, I find that the landlord's mitigation efforts were reasonable. I find there's no general issue of material fact that the lease, which, as I indicated earlier, was valid and enforceable based upon the prior litigation in the landlord-tenant division of the 36th District Court. That's a res judicata issue. I find it was valid and enforceable. I find that the Delgados breached the lease and that they are therefore liable for the damages caused by the breach of that contract. Therefore, I find that I will grant the plaintiff's motion for summary disposition. The defendant's motion for summary disposition is denied in its entirety. I am also denying or dismissing the defendant's counterclaims in their entirety. I am ordering damages awarding in the amount of $13,491.92 for the breach of the contract, plus the statutory interest from the date of filing of the complaint, the court costs of $229.48, and the attorney fees in this matter. Anyone who is aggrieved by our decision has an absolute right to appeal. That decision must be perfected, that appeal must be perfected in the 21 days of today in the Wayne County Circuit Court. And I want to thank you both for your extensive briefing, and you were both very well prepared, and I appreciate that. You have no idea how painful it is as a judge to argue or have a motion for summary disposition when the parties haven't bothered to prepare their own cases. Ms. Newman, you will submit to me the order under the 7-day rule. Thank you both for coming in. Mr. Riddell, is there something you want to say? Sir, you muted yourself.
Thank you. I'm sorry, Your Honor. I do want to address 2 issues on the issue of damages.
Sir.
Since I didn't brief those since I was just addressing liability. On the issue of attorney fees, the breach of contract claim doesn't allow for attorney fees, and therefore the defendants object to the inclusion of attorney fees. The landlord is left to.
No, I was speaking of the statutory attorney.
I see. Okay, under the court rule. Okay, and thank you. And then the one other issue I want to point out is that in the complaint, the plaintiff is seeking the costs that were awarded in the landlord-tenant case, but in this GC case, and I believe those are inappropriate. Those should have been collected if they wanted to collect them in the LT case.
Ms. Newman, the costs that you're asking for, are those the costs of this case, of the filing and service of this case?
The costs that I've broke down, yes, are for this case.
Yeah,
included in the overall amount that Your Honor awarded. There are costs from the landlord-tenant action because we did not obtain a money judgment in that action. We only obtained a possession judgment.
Court will not award those landlord-tenant judgments because the only thing you saw in the landlord-tenant was possession. So when you submit your order in relationship to costs, limit your costs to the cost of the litigation that's here, not the landlord-tenant.
Thank you, Your Honor.
Thank you both.
Your Honor, and what you indicated, so you're not allowing our claim for attorney's fees, then you're only allowing the statutory fee?
Yes, that's correct.
Because the lease does allow for the cost of having to enforce the provisions of the lease under paragraph, what was it?
Paragraph 6 limits your remedy to all damages caused by their default, including costs of renting the property, the premises, and all rent for the remainder of the term the landlord does not collect through mitigation. Does not mention attorney fees. That's your paragraph 6, default and remedies. So apparently everybody's unhappy with my decision. So be
As
it.
we like it.
So be it. And you'll submit a 7-day order, Ms. Newman, consistent with my decision. If you want to appeal the issue of cost from the landlord-tenant division, you certainly have an absolute right to do that. That appeal must be perfected in 21 days of the date of the entry of the order. Mr. Riddell, if you want to appeal any of my decision, you have an absolute right to do that. That appeal must likewise be perfected in 21 days of the date of the entry of my order. Look forward to your order, Ms. Newman. You guys have a great day. Mr. Delgado, thank you for coming in.
Thank you, Your Honor.
We now